If there are three rules in Washington, D.C., they are never get between a politician and a camera, never let a crisis go to waste, and when in doubt, pass more legislation. Now, the Justice and Policing Act of 2020 really should be called the George Floyd Federal Power Grab Act of 2020. And we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and we teach the rising generation to be free. I am so glad you could join me. As always, I want to send you to the website, constitutionstudy.com, to where I have everything I'm working on. I've got some new ideas coming up. I've got some new products coming up. Most of all, I've been doing a lot of articles and videos regarding the lockdown, the shutdown, the power grabs. Again, this is just another one of them. Mostly, I'm hoping you'll engage. I love getting comments. I love getting questions. I hope you'll engage in the process. I hope you consider supporting the work that we're doing. But most of all, I want you to get engaged. I want you to realize that you're not alone. There are millions of Americans who are probably thinking the same things you are. And if we start getting together, we can really make a change in this country. It's not going to happen through party, and it's not going to happen in the next election, but it starts with each and every American being willing to understand what their rights are, how to protect their rights, and how to protect the rights of others. So head on over to the website, constitutionstudy.com, see how you can engage, how you can make this a better America just by spending a little time getting yourself educated. With that, let's talk about this Power Grab Act. Politicians seem to need to be seen to do something. Well, then again, it seems every time something bad happens, the American people cry out that their politicians have to do something. It seems people never stop to think that doing the wrong thing could actually make things worse rather than better. A case in point, the so-called Justice and Policing Act of 2020, or as I call it, the George Floyd Federal Power Grab Act. Now, I understand. After watching the video of the death of George Floyd, I wanted something to be done too. What I wanted was the officers involved to be investigated, charged, and have their day in court. Now, so far, 2 out of those 3 things have happened. The officer who killed Mr. Floyd is in jail facing murder charges, and the other officers involved, well, they're facing charges of accessory to murder. And while I'm willing to wait for evidence to be produced in court for justice to be served, well, there are a lot of Americans who are not willing to wait. Chief among them are the 230 members of the House of Representatives who are using this crisis to grab more power for the federal government. Now, if a stopped clock can be right twice a day, I suppose it is possible to find something legal and good in such an atrocious piece of legislation. Section 102 of this legislation does propose some reforms to 42 U.S.C. 1983, specifically the language for what is referred to as qualified immunity. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to be deprived of any rights, privileges, or immunities secured by the Constitution and the law, shall be liable to the parties injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purpose of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. The general idea of 42 U.S.C. 1983 is that if a government actor deprives you of any rights, privileges, or immunities protected by the U.S. Constitution under the color of law, well, you can sue them in civil court. Now, this is different from 18 U.S.C. 242, which is a criminal offense for depriving someone of their rights and privileges. The problem is the language, quote, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. See, this protects the officer from damages unless a declaratory decree was violated. In other words, a government officer cannot be held liable for violating the Constitution unless a court had previously stated that such a violation is actually a violation. This is the so-called qualified immunity, and it has been used to protect officials, especially law enforcement officers, from the consequences of some very serious acts, some of which I've actually written about and done videos on, like the case of Jessup versus the city of Fresno, where the court basically said that police officers could not be sued to recover property stolen during the execution of a warrant because, quote, at the time of the incident, there was no clearly established law holding that officers violated the 4th or 14th Amendment when they steal property that is seized pursuant to a warrant. So what is Congress's response to such a travesty of justice? Well, quoting from the bill, Section 1979 of the Revised Statutes of the United States, 42 U.S.C. 1983, is amended by adding at the end the following, quote, it shall not be a defense or immunity in any action brought under this section against a local law enforcement officer, as such term is defined in Section 2 of the George Floyd Justice and Policing Act of 2020, or in any action under any source of law against a federal investigative or law enforcement officer, as such term is defined in Section 2680H of Title 28 United States Code, that, quote, that the defendant was acting in good faith, or that the defendant believed, reasonably or otherwise, that his or her conduct was lawful at the time when the conduct was committed, or the rights, privileges, or immunities secured by the Constitution and laws were not clearly established at the time of their deprivation by the defendant, or that at such time the state of the law was otherwise such that the defendant could not reasonably have been expected to know whether his or her conduct was lawful. Okay, that's a mouthful. So now, if the officer believed, reasonably or otherwise, that their conduct was lawful, they get a pass. Does that mean if you believe, reasonably or otherwise, that what you're doing is legal, then you cannot be sued? Well, tell that to the Texas farmer who was fined for constructing stock ponds on his land in accordance with the very same EPA that created the regulation exempting them from review. Or the 2 citizens in Kansas who believed their governor when he said that he would enforce the Kansas Second Amendment Protection Act. You see, this creates a 2-tiered justice system where those who work for the government receive special protections. This is one of the grievances our founding fathers listed as justification for declaring independence. Quote, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. You see, most of the rest of the legislation involves effectively federalizing your state and local law enforcement. From the legislation, quote, in carrying out the authority in subsection B, the Attorney General may require by subpoena the production of all information, documents, reports, answers, records, accounts, papers, and other data in any medium, including electronically stored information, as well as any tangible thing or documentary evidence, and the attendance and testimony of witnesses necessary in the performance of the Attorney General under subsection B. Such a subpoena in the case of contumacy or refusal to obey shall be enforceable by order of an appropriate district court of the United States. That means if this bill becomes law, your local law enforcement will not need to be charged with a federal crime for them to be required to report to the U.S. Attorney General. What's more, should your state's Attorney General believe a violation has occurred within the state, they no longer need to seek relief in a state court, but they can take it directly to a federal one. Quote, whenever it shall appear to the Attorney General of any state or such other official as a state may designate that a violation of subsection A has occurred within their state, the state attorney general or official in the name of the state may bring a civil action in the appropriate district court of the United States to obtain appropriate, equitable, and declaratory relief to eliminate the pattern or practice. In carrying out the authority in this subsection, the state attorney general or official shall have the same subpoena authority as is available to the attorney general under subsection C. See, no longer will your state or local law enforcement be held to conduct established by state law. Effectively, all law enforcement will not only be subject to federal regulation, but abuse and usurpation as well. And as is almost always the case in such federal legislation, well, there's a nice tiny little bribe to the states. 30 pieces of silver for abdicating their authority to protect their citizens from federal overreach. Quote, the Attorney General may award a grant to a state to assist the state in conducting pattern and practice investigations under 210401D of the Violent Crime Control and Law Enforcement Act of 1994. Now, what is this bribe to be used for? Quote, beginning in the first fiscal year that begins after the date that is 1 year after the date of the enactment of this act, a state or unit of local government that receives funds under the Byrne Grant Program or the COPS Grant Program during a fiscal year may not make available any amount of such funds to a local law enforcement agency if that local law enforcement agency enters into or renews any contractual agreement, including a collective bargaining agreement, with labor organizations that would prevent the Attorney General from seeking or enforcing equitable or declaratory relief against a law enforcement agency engaged in a pattern or practice of unconstitutional misconduct or conflicts with any terms or conditions contained in a consent decree. That's right. Any state that takes this bribe will have to make sure that any labor contract they sign cannot prevent them from turning over to the federal government the information they want. In fact, any contract. That's not all. This legislation also includes bribes to the states to enact policies for the use of federally approved independent investigation agencies or civilian review boards. Now, I've already mentioned how this law puts your state and local law enforcement under federal control. There's actually an entire subtitle, euphemistically called the Law Enforcement Trust and Integrity Act. It should more accurately be called the Federalization of State and Local Law Enforcement Act. This act wants to put the Attorney General of the United States in charge of accreditation of each and every law enforcement agency in the nation. Quote, after completion of the initial review and analysis under paragraph 1, the Attorney General shall recommend, in consultation with law enforcement accreditation organizations and community-based organizations, the adoption of additional standards that will result in greater community accountability of law enforcement agencies and an increased focus on policing with a guardian mentality, including standards relating to early warning systems and related intervention programs, use of force procedures, civilian review procedures, traffic and pedestrian stop and search procedures, data collection and transparency, administrative due process requirements, video monitoring technology, youth justice and school safety, recruitment, hiring, and training. Now, is it a good idea for law enforcement to have standards regarding these activities? Yes. But it is most definitely not the role of the federal government to set those standards. It is a violation of the Constitution, of the rule of law, and the separation of powers between the states and the central government. Furthermore, when this legislation lists community-based organizations, well, they mean, quote, the term community-based organization means a grassroots organization that monitors the issue of police misconduct and that has a local or national presence and membership, such as the National Association for the Advancement of Colored People, the American Civil Liberties Union, Unidos US, the National Urban League, the National Congress of American Indians, or the National Asian Pacific American League Consortium. Now, does anyone notice a pattern for these community-based organizations? These are all groups that have expressed dissatisfaction with the police. In fact, many of them have openly opposed our Republican form of government. And they are all national organizations, not community-based. These are the people the federal government says should be overseeing your law enforcement. Now, should they have a seat at the table? Well, absolutely. But so should organizations like the Fraternal Order of Police, the United Deputy Sheriff's Association, and the National Association of Police Organizations. You see, if we want better law enforcement, those agencies must be willing to listen to both sides of the argument. And that's not all. You see, this legislation requires not only that law enforcement be monitored, but that the data collected be made available and, at his or her own discretion, reviewed by the Attorney General of the United States. So effectively, all decisions about hiring and standards for your local police and your state police will now be subject to the Attorney General of the United States. Now, should law enforcement be held accountable? Or should their actions be subject to review by individuals and community-based organizations? Should law enforcement officers be held both criminally and civilly liable for their actions? The answers are yes, yes, and absolutely yes. However, you cannot fix a problem with law enforcement by breaking the law and making the process more political. History shows that there will always be people who will use the system for political gains at the expense of justice and liberty for the people. If we want law enforcement to be more accountable, the answer is for them to be held accountable locally. If we want a more just police force, well, then we should hold them to the same standards the rest of the people are held to. And if we need to fix some of the laws, the last thing we need to do is turn it over to the federal government and have them run everything. If we want justice for George Floyd, then let those charged with his murder have their day in court. Let them be judged by a jury of their peers, and let the facts of the case become public. It is not justice to punish approximately 700,000 American law enforcement officers because you are mad at how long it takes to grant a few bad actors their due process. Little, if anything, in this legislation would have any impact on what happened to Mr. Floyd. So this is one case where doing something not only will not help, but it will make things much, much worse. So if you want to see justice for George Floyd, then allow the system to get justice for George Floyd along with those accused of his murder. Justice, not vengeance. And if we do need to make changes to law enforcement, and I believe we do, let's focus on where the problems are and not turn this into a political football. Not turn everything over to the federal government. Not turn everything over to a political office. Because while the Attorney General may be the chief law enforcement officer, it is a political appointment. Do you really want the standards for your law enforcement officers judged by politicians? Or do you want to be involved in the standards? Do you want to hold those law enforcement officials accountable? Now, there are a couple things I think we should do. I would love to see a reform to qualified immunity. The problem isn't so much with the language of the law, which does need a little tweaking. It's with how judges are applying it. And when a judge makes an incredibly stupid decision, like saying there's no reason why a law enforcement officer would know that it's wrong, that it's illegal to steal during the serving of a warrant, well, that judge needs to be removed. That's not good behavior. Now, if it's a one-off situation, that may be one thing, but it's this history of abuse of the systems we put to protect ourselves and our law enforcement officers that have led us to this problem. Before we throw the baby out with the bathwater, how about we just clean the bathwater? And before we turn everything in our lives over to the federal government, ladies and gentlemen, when will we grow up and act like adults? Not everything is a federal issue. The last thing I want is the federal government telling me how my law enforcement should work. I want that local officer, I want my deputy sheriff accountable to me. And right now that happens through the sheriff, right? If the deputy doesn't do his job, the sheriff gets fired. If the sheriff won't fire a bad deputy, that sheriff doesn't get reelected. All we have to do is work the system. Now, does the system have problems? Yes. But do you really think it's going to be any better when the decision is made by some political appointee? Someone who has an agenda? Who maybe thinks that all police officers are racist? And that anything that involves a use of force against a black person is automatically racist? Or that any action against an illegal alien is racist? Or that enforcing the law that they don't like is police brutality? If we turn this into a political football, things are going to get much, much, much worse. And remember, these are the same politicians who are sitting back and watching cities like Seattle and New York and Washington, D.C. burn, that are watching public property, public monuments being torn down, that are watching private property be looted and destroyed and doing nothing. Do you really want to put them in charge of your law enforcement? If not, it is time to get on the horn with your representatives and say, no, this is not acceptable. No more. Stop sitting back and acting like you can do nothing. You have the power. Individually, yes, one vote makes no difference. But if you don't vote and you don't teach others the importance of voting and voting based on the Constitution and these people's oaths and not what goodies they promise, then we will become the tin pot banana republic we've been becoming. We will become the Marxist nation where the central government rules everything, where your life is determined and dictated by those in political office. And if that is what you want, well, there are plenty of countries that do that. Millions of people come to America to get away from that. What happens when we turn America into the same cesspools these people are leaving? No, let's not just do something. Let's make sure that we do the right thing and that we do it properly and that we follow the laws. And when the laws need to be fixed, we fix them through the process that was created. Because if we don't, America will no longer be the land of the free and the home of the brave. It'll be the home of the Marxists and the land of tyranny. Hopefully you'll see how important this is. Hopefully your eyes are being opened. And I hope to see you again the next time on the Constitution Study.